Hello, everybody. Uh-oh. My Wi-Fi is already only showing like 1. Hold on. Let me turn off my... All right. Let me see if that's better. Sorry, guys. Technical difficulties over here, as always. Hi, Ava. We're having bad storms right now, so that's probably part of it. Yes, really bad storms. Okay, it kicked up a bar, and it went down a bar. Oh, I really hope my internet holds out tonight. Oh, my goodness. Oh. It says I'm supposed to have a good connection. I'm trying. All right, we're going to go with it. We're going to roll with it. Hopefully there's no issues. No issues. Oh, I only gave you 1. Mama is off her game. I just took a shower. I was trying to not be all shiny when I came on here. And I failed. Oh, Bandit, you already had some treats. There's a few. Oh, what if I put this little box up here? All right, let's see if that does anything better. Hi, baby girl. One more. All right. Hello, K-John Boom. Hello, C-Rex, honey. I hope you're still awake. Hello, Jerry Matthew Boyd. Hello, Buzzy Pug. Welcome. Hello, Nana Laura. Hello, Senior. Oh, I had a Monday kind of Friday. Oh, no, I hope this makes it better. I'm so happy to see you. Hello, Catherine Gaston. Oh, my. Is that like a prerequisite? Elevators fail and then seismic activity. I hope not. I hope not. Hi, Mama. Yes, we were getting hit hard too. That's what I'm saying. Hello, Eileen E. Carlin. Hello, Linda Applegate, sweetie. Hello, Michael Psycho 1. Let's see, did I get everybody? Did I? Hello, Manuel. You guys are amazing. Hello, Mortimer Duke. Hello, Lisette Bennett. No, I just need to run a cable. I need to run a cable under my carpet from my now bedroom, living room, and into my previously bedroom office. And I need to run it under the carpet. Or someone suggested that, Ava, I want my hand. Someone suggested that there's already holes in this room and that room to go down to the drop ceiling in the basement. So they said, oh, it's so easy. We'll just run a cable and then pull it through. So I've been like playing in my head all of the scientifical ways of how I can accomplish this. And I might do that. I don't know yet. I don't know. But my hair is wet because of the shower. So y'all are just gonna have to deal with me for a little bit being obsessed with this because it's driving me crazy. Oh, I gave myself an hour and then I jumped in the shower, and that's apparently how long it takes for me, because trying to take a shower and having the spinal issue, and yeah, it's not easy, but I accomplish it. I get it done. Hello, Karen. Great to see you. Hello, Spider-Man, honey. Oh my gosh, you guys are so awesome. Yeah, yeah, yeah. She's very important, and she knows it. She's very spoiled. It's not active, and I called Spectrum, and it would cost $125 to activate it. $125. And I mean, realistically, the cable is there. The box is there. They'd flip a switch on their end, but they have to send a technician out to do it. Whatever. I'm not paying $125. I will run the damn cable. Well, not all of that time is in the water, silly. But it takes a long time to get in. It takes a long time to get out. It takes a long time to get dressed. Yeah. And my hair is just not drying because it's so humid. My AC can't keep up today. Yeah, but it's the fastest around here. It's that or dish. And I can't rely on that. I can't rely on satellite. I've seen it go out too much. Tell me about it. Yeah, I know. And they've got you by the balls. They really do. I don't know what you had to do to who, but they don't give me that kind of treatment. Not around here. I have never heard of that. I've never heard of them. We have Lynx. Lynx is the other one, but they're like boosted dial up. Well, aren't you just special? Well, you are special. Hello, Peg Leg. I love you. Oh, thank you, thank you, thank you. I'll use that for the cord. I'm going to use clothesline cord because it's the same thickness as the cable. I'll get this. I will get it done. I will do this tonight. I will. I'll do it tonight after the stream. Nice. Nice. Well, I pay for the boosted package. I don't have like the minimum. I have like the highest 5G and all that speed and everything, and it's still wonky. I mean, you guys see how often it goes down. I finally have enough connection to support streaming. Well, it keeps floundering, but I'll get it there. I mean, we'll do what we can. I and tomorrow it'll be different. Tomorrow it'll be better. I can't promise any less, technical difficulties, because that's just how I roll around here. But the connection will be stronger.
Okay, so back on the record, this is a case of Richard and Jean Ellaway and Abigail Nutu. Case number 39038. And this case was initiated by the Elloways against Ms. Nutu. Ms. Nutu filed a counterclaim, and this is the factual scenario I spoke about in my opening speech, where there was an accident. Both of you are pointing fingers at the other party, and it's to be up to me to figure out who's at fault here. And so before we do that, Ms. Ellaway, could you raise your right hand, please? Do you swear and affirm the information testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. And then go ahead. I'll hear from you first, and then I'll hear from Ms. Nutu.
Okay. On that day, I was driving and I was on the main road, and all of a sudden, I was on the main road, and when Miss Nudu suddenly collided with my vehicle on the right, and she made an illegal pass to my right side, and the speed that the car was going was really fast, Your Honor, and she never stopped until she went to Galenta, and she made a right. She swerved over to the right lane and stopped, and she never got out of the vehicle. I followed, and I was waiting, and she never got out. Yeah.
So you hit her, and as far as I can tell, you hit her in her left driver's side rear. Is that correct?
No, Your Honor. She hit me.
Oh.
She hit my vehicle. I was on the main road, and all of a sudden she was passing, and I in front, and she was already going ahead. And because I didn't want to hit her further, I swerved towards the left and stopped my vehicle in the middle of the road. And she continued moving forward.
Hang on just a minute, ma'am.
Yes.
So were you both traveling on, and again, a main road, I'm talking Crosby Boulevard. You were on Crosby Boulevard?
Yes, sir.
And give me just a second. Okay, so were you there's a narrative report filed in the from the looks like a police.
Yes, sir.
And then there's also a diagram.
Yes.
And then I'm going to read to you what's in this report, and I want you to tell me if this is accurate or not.
Okay.
It says, I then talked with Jean Ellaway, the driver of Vehicle 1. She told me the following. According to Jean, she was stopped on Viewpoint Court preparing to turn left onto Crosby Boulevard. Jean said she looked both directions for traffic. She said she saw none, moved out into Crosby Boulevard. During her turn, Jean said V2 came out of nowhere. Her vehicle struck V2 on the rear driver's side. Jean's vehicle sustained reportable damage to the front passenger side corner, and she did not have any injuries to report in her vehicle. And so then I'm going to show you another thing here that's also in that report that I printed this off. If you look here, it may be hard. This is a disadvantage but that's what was submitted by the officer. And that's kind of similar to what was described in that paragraph. The car coming out of, can you see that first of all? I'm going to pull that up there.
Yes, Your Honor, I see that.
So the come out is identified as your automobile. V2 is the automobile driven by Ms. Nutu.
Yes.
So is this diagram wrong? And did the police officer, when he wrote all that down, is he wrong or what exactly? Because I heard I'm trying. It's hard for me to figure out exactly what you're telling me.
Okay, that was from the first police report, Your Honor, and I made 2 more attempts in going to the police station to correct that report, because that is Mr. Nutu's version to the cop. That is not what I said to the cop. I was not turning left. I was already on the main road. I was on Crosby when Miss Nutu suddenly hit my vehicle. I was not turning left.
What kind of car were you driving, ma'am?
Subaru, sir. That police report has been amended 2 more times.
Is that the amended police report been filed?
Yes, sir. Did you?
Yeah, it's in the
It's in the file, zip file, Your Honor.
So what exhibit? What number? There's exhibit. There's all kinds of exhibits here, and
Exhibit
is it
D.
numbered?
It's Exhibit D. Police
Thank you.
report supplemental.
And sir, you're not sworn in, and so I'm not going to hear from you. If you want to testify, I'll let you testify, but you need to sworn in first. Do you understand that?
Yes, sir.
Exhibit. I don't see that in Exhibit D. Exhibit D is looks to me like an insurance company thing.
No, it's
Page 1.
1, 2, and 3.
D1. Hang on just a minute. Oh, there we go. It says I amended the diagram. Okay, so hang on just a second. So the pictures image. So it looks to me, okay, hang on just a minute. I'm going to hear from Ms. Nutu. Ms. Nutu, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Were you driving a Toyota?
Yes, I was.
Okay, I'll get back to that in a minute. So ma'am, the picture presented, there's a couple of pictures here. And which I assume is yours. There's a picture of a Toyota, which is, I assume, is Ms. Nutu's. And did you send these pictures, Ms. Nutu?
Yes, we did.
And then did you take these pictures right there with your phone?
Yes, I did.
Okay, so ma'am, I'm going to come back to you. And it looks to me like the damage to your car is on the front passenger side. And the damage to Ms. Nutu's car is on the rear driver's side, which would be consistent with this diagram. That's what that shows. And I don't see how, if she was in, how did, I'm not following what you're telling me. You're saying she hit you?
Are you referring to
No,
me?
you're just talking to
Yes,
me.
I am.
Ms. Jean Ellaway?
Yes, Gene Ellaway.
Yes.
Because it looks to me like the only way that
She hit me,
she
sir.
hit you?
Yes. I was on the main road and all of a sudden there's a slam to my right. And then she just tried to pass me and then she went straight and she was at high speed. She never stopped. She never honked her horn, nothing.
She never braked.
She never
Okay, so
she never
Mr.
did a break.
So, I don't understand how the back of her car could collide with the front of your car. That's what I don't get.
Swerving in
She
front.
swerved right
Right.
to my side, up to the right embankment and went straight.
Okay.
So she hit me on the right.
She tried to cut
And
around.
she tried to cut and then she never stopped. She went straight.
I really wish we'd get to see the pictures, because if her version is true, the damage would be on the side of her front panel. I mean, that'd really be the only way. But the judge is saying that the damage was to the front of her vehicle. That would be a really hard swerve in order to get that angle.
So I'm gonna hear from Ms. Nutu. Ms. Nutu, could you raise your right hand, please? Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. I'll hear what, according to you, what happened out there?
So I was driving down Crosby Boulevard, and as I'm approaching, I see her car. She's on the side street. It is Viewpoint Court, and I see her car. And as I'm approaching, I see her starting to come out and make a left-hand turn. And I didn't think too much of it. I was like, oh, she shouldn't have been pulling out yet, but obviously I assume she stopped, and I continue. And as I am crossing like the street, I noticed that she's still accelerating towards me. And out of caution, I swerve into the bike lane a little bit and I speed up to try and avoid that. I didn't think that she would actually hit me. I just thought it would be another one of those close calls that happens, but she did end up hitting me, and I immediately pulled over as soon as I could. And I was obviously shaken up. I had never been in an accident. I'm young. I don't really know what to do in these situations. So the first thing I did is I called my father, of course, and he said he'd be coming and that an officer was on the way. And then I get out of my vehicle and I take pictures of everything. And Miss Ellaway also exits her vehicle when I come outside as well. And she tells me she's late for an appointment and she wants my insurance, and she's saying she's late and asking if she can leave. I say, no, you cannot. We have an officer on the way to get this all taken care of. That's the only time I spoke to her, and then went back in my car, and I didn't get out until the officer and my parents had arrived there as well.
Ms. Ellaway,
Yes,
and
sir.
again, so tell me again what happened there from your point of view.
Okay, so I was on the main road, and then all of a sudden I heard this bang on my car, and she was moving, and then I swerved a little bit to the left because I didn't want to hit her further, and then she just went, I heard the car, and then she just went straight. She just went straight, and then she parked towards Galenta, past Galenta Street or Avenue or whatever that street is. And then she didn't come out of her car. And then she just said that my father, and then she didn't stop. She didn't make, it was just a big, like that. I just heard boom. And she just went going straight. I did not make a turn, Your Honor. I was already on the main road. I was on Crosby. And then when her father came, all of a sudden he was telling he said that, oh, you were turning left. I said, no, I was not. I was on the main road. And that's when he called the cop. He said, I'm calling the cop. And all this story on the first report was not what happened. That's why I had to go to the cop 2 times, because I said, I'm not being heard here. This is Mr. Nutu's version. And in fact, when in the police report, before the police left, the officer, he said, this is no fault. And then all of a sudden, I received the police report, which is Mr. Nutu's version. I was not turning left. I was already on Crosby Road when she hit me.
So it's your position. I mean, again, okay. Give me just a minute there, ma'am. So again, going back to this diagram here on Viewpoint Court, where that car is, do you live on that street, ma'am?
Yes, sir.
And is this about where this happened? Just outside of Viewpoint Court?
I was already on the main street.
I heard that, ma'am.
Yes,
I
sir.
heard that.
Yes.
Okay.
So I have already made the safe turn from Viewpoint Court.
I see. So you did turn off Viewpoint Court?
Yes. And I have already made the safe turn. I was on Crosby, and all of a sudden I was hit. We have to consider, Your Honor, that that's a descending road. It's a curved road, and you have to.
I'm familiar with it.
Yeah.
I'm familiar with it. I'm familiar with it.
Limited visibility now.
So I have questions for you both, and that is, you're both making claim against each other. The reason I ask this is without saying, who I'm deciding for, if insurance covered this and insurance paid for it, and you have to pay for it, you're maybe subject to a deductible. I can't enter a judgment, like the insurance will pay for it, and then I can't enter a judgment in the amount of what the insurance paid for, because that should go to the insurance company. And so I guess I'll start with you there, ma'am. It's Ms. Well, here's what's going to happen. And so, ma'am, I heard what you're saying about, you had already made the turn and we're on, but given where you were turning off of Viewpoint Court onto Crosby Boulevard. When you turn onto the lane and that, when you turn onto the road in that particular position, you have to yield the right of way to the person on Crosby Road. And if this was about where this happened, and it doesn't make sense that if they slammed into you from behind, that would be one thing, but your front clipped their behind. And so maybe, you misjudged. It said in the police report, you didn't see them coming. Perhaps, I'm not sure what exactly happened other than maybe you misjudged her speed, or if you didn't see, and if she was already on the road, and then it seemed to me not be possible for her to hit you with on her left rear bumper to your front right bumper. That just doesn't make any sense. Perhaps you didn't see, you misjudged how fast she was going, but I am going to find that the preponderance of the evidence is that Ms. Nutu's not at fault in this case, and if there is any fault, that lies with you, in that you misjudged the turn, misjudged her speed, or what have you. And so Ms. Nutu, and again, and I assume who's there with your father, what's the status of all this? Did insurance cover this, and was there a deductible, and what exactly?
Yeah. Yes, Your Honor. Can I talk? Is that okay?
Yeah, raise your right hand. Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
That is, yes.
You can put your hand down. What's the insurance situation?
Insurance situation is the plaintiffs in this case, Your Honor, were uninsured. They were cited for not having insurance at the time of the accident. Luckily, I have uninsured motorists, so we went through our insurance company to fix our car. So we did that, and we got our car fixed, and lo and behold, after, I don't know, 3-4 a month, we get a sheriff coming to the door issuing us a summons report.
No, I just want to know what your deductible is. What did you have to pay?
The deductible was $1,000, but it ended up being only $100 for uninsured motorists under my policy.
I see.
It only cost us $100 out of our pocket to get our car fixed.
Did you have to pay a filing fee for the counterclaim?
I did, Your Honor. It was like,
how much was that?
$75. What the standard procedure was, and then I paid the sheriff too. I left.
How much was that? $60 for the service fee?
Yes, Your Honor.
Testimony.
Now, is there anything that we're able to do about the diminished value for my vehicle? The damages that I'm seeking on.
I can't. Before you stop there, I'm just gonna stop you and say, I can't give you advice in that regard. And so, you can talk to a lawyer if you want about all of that, but I can't, you don't want me telling them how to conduct their case. I'm pretty confident they don't want me to tell you how to conduct yours too. So I just, you're here, you both pointed the finger with regard to the accident. The only thing I'm deciding today is, and she's asking for emotional distress, which I can't, I don't think that's appropriate. I'm finding that, just for the purposes of this hearing, I'm finding that your daughter's not at fault. The fault lies with Ms. Ellaway. I'm going to reward you with principal and the deductible, and I'll give you your costs and fees. And but that's really what I can, if you want to pursue other action,
I don't need anything
maybe consult
else,
a lawyer.
That'll be fine with us today.
All right.
Sir, could I say something?
Yeah, could you raise your right hand, please?
Yeah.
Do you swear and affirm the information and testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Go ahead.
Yeah, I just would like to say that, my wife, English is her second language, and I believe her communication with the police of what happened was limited. And then I feel that this uninsured issue, that was my oversight, and I deeply regret that. I got insurance the next day. No.
But see, hang on, but I'm going to stop you on the insurance thing because I want to say that had no bearing on my deciding of the case. That's why I announced what I was
Right.
going to do before I asked about insurance. So insurance only affected the amount of the judgment.
Yeah, yes,
But
Your
so
Honor.
that, go ahead.
But it may have influenced the police officer because he was definitely not listening to my wife. I was there when they were talking, and before he left, he asked her point blank, "Were you going down the straightaway in Crosby Boulevard?" And she said yes. And then he never put that into the report. And the other issue is the damage. I mean, there's a swipe. It swipes on the bumper towards the left. And were you able to watch my video, Exhibit A?
No, give me a second. I did, but I can review it now.
Yeah, because I feel that this is a little more complicated than it appears, because when you come around that bend on Crosby Boulevard, you're almost completely blind until you're, looking at, or you're within like 100 feet of it. So it's very possible that the version that my wife presents is true and real, meaning that she was already descending and that Miss Nutu did not see her make that turn. And I still wonder why she didn't brake or why she didn't honk or, anything. So I actually timed it out very carefully, from listening to what my wife said. And there's about a 6-second delay, and that would fit with both versions. Like both people could be telling the truth. So
Well, the other thing is, one thing I will say about, I did consider, then the video's loading. I didn't, and I just kind of decide the case based on what's presented to me and, the pictures and all of that. But, videos after the fact generally, frankly, aren't that helpful. But, I will say this, what I did hear from Ms. Nutu is she did try to avoid it. She saw the turn, she tried to speed up, and she almost made it. I mean, if you look at where you hit, if she'd have just been like 2 feet further ahead, we wouldn't even be here. And
Right.
so, I mean, that's just what I heard her say. And I did consider that in making my decision. But the insurance is just a non-issue. The judgment's going to be principal amount of $100. Filing fee is $50. A service fee is $60. So in terms of damage, I'm not given a win the amount of, and I do know that body shops are, given my work experience here and what I see, and for lack of a better term, or fender benders, which this is, frankly, a fender bender. I know that body shops are very expensive, but the insurance company paid for that. I'm not giving a windfall to the Nutus for all of that. They're just getting their deductible as well as their filing fee. So the total judgment amount is $210.
Sir, just their insurance company, we thought this was a no-fault accident. That's what we were told by the police officer. We were actually shocked to see that report. And their insurance company is coming after us now for $7,000. And this is why we're here today.
Okay. I'm going to tell you, I'll tell you something else. I mean, this hearing, this isn't, I mean, I don't know what to tell you other than the insurance company can do with what they think's appropriate. And apparently all I know is what I'm deciding here today, how much weight the insurance company gives that. And apparently the insurance company decided to do that well before anything happened. And also, for the record, I didn't know anything about that till right now, until you just told me, but I'm just deciding the case based on what's presented to me.
Well, can I ask a question?
Yes.
My understanding of Washington state law, if someone's in an intersection, what my wife says she was already out going descending, doesn't she have the right of way with someone coming? I mean, and then if there's not
the person turning onto, again, based on what I've seen in terms of the testimony, when you're turning onto or coming onto you have to yield to oncoming traffic.
Your Honor.
And that's what I'm finding. And maybe she didn't come out, and she maybe misjudged the oncoming car. And you're at the speed of the oncoming car, but it's there again. That's what I'm finding.
On the video, you can see you can only see 200 yards there. So it's very like she could have passed, and again, not seen a car coming. There's a very limited visibility from viewpoint.
I was already on Crosby,
Okay.
Your Honor. I wasn't turning left. I was already on Crosby.
Okay.
And
And so,
I'm a very safe driver.
yeah, I don't doubt that, ma'am. Yeah, and I'm not, my decision doesn't mean you're not a safe driver, but sometimes, things happen. They do. And, and I'm asked to decide the case, based on what's presented to me and based on what's presented today, to me, this is my decision. And that's, you can appeal this if you wish. Of course, every decision can be appealed, but, that's my decision here in this case.
I just feel like, on Your Honor, that I have not been heard since the beginning. I had to go to the police station 3 times in order to correct the police report.
You have been heard. You have been heard fully. Everyone has heard you. The problem is no one believes you. And you just don't like that.
I have not been heard since the beginning of this, because this is all Mr. Nutu's version to the police, and that's the thing that the police put in his report. I was on the main road. I was on Crosby when Miss Nutu hit me. I wasn't turning left. That was Mr. Nutu's version when he was accusing me.
Yes, Your Honor. And I asked Mrs. Nutu why she tried to go around her, and she said she thought she was turning left. And to me, that was evidence that she was on Crosby and not turning.
Yes.
Because
No, that was evidence that she was turning onto Crosby when Miss Nutu saw her. Not that Miss Nutu assumed that she was going to turn off into some cornfield along the way. My goodness, man, your wife is lying to get out of responsibility. Just accept that.
it wasn't that she didn't say at the time that she ran into her. She said she thought she was turning left. And if you see on the video, there's nowhere to turn left there. So I think she's changed her.
I think she was turning left. She was turning left off a viewpoint. Then she tried to go around
She
her.
thought she was turning left off of Crosby.
I was already on Crosby, and then she said, I thought you were turning left. Meaning she thought that I was turning left towards the park or towards the residence driveway on that side, but I was already, there were no 2 lanes. There was just one main lane and another on the ahead was a left turn.
So hang on just a second. I'll allow Ms. Nutu to respond, and again, we'll go. Ms. Nutu, you heard what she said. Do you have a response to that?
Yeah, I do. I did not speak to Mr. Ellaway or Mrs. Ellaway. I never said those words. I actually have no clue what they're talking about. She was turning left off of Viewpoint and coming onto Crosby. It's as simple as that. Their story keeps slightly changing. They're saying things that I said. I didn't speak to them. As I said, I was very scared, so I waited for my dad and the police to arrive because I didn't know how to go about things, and I didn't speak to them about what I thought she was doing or anything. It was simply that she was coming out left and she tried to merge into the lane that I was in and hit my back corner.
Your Honor, I did talk to her, and she did say she thought she was turning left.
So again, I've reviewed the pictures, which are telling to me is where the person hit, and my decision. I've heard your comments, and ma'am, I did hear you. I did listen to your testimony, and this is just the decision that I'm making. And as I said before, when you get 2 different versions of the same set of facts, they have to come one way or the other. And usually, and I understand you're not happy with my decision. I get that. I get that you disagree with it, but that's my decision here today. And again, the principal amount on the defendant's counterclaim is $100, $50 filing fee, $60 service fee. Total judgment amount is $210. And then that'll conclude the hearing here for today.
Thank you, Your Honor.
You both are free to go.
Thank you.
Oh, that one was so good. I loved it. I knew that you guys would enjoy that. Yeah. I am kind of a little surprised that did not come out. Just a little bit surprised. I was actually expecting that. Just by the way they were acting, and that they were already using the excuse that it was because of a language barrier to the cop, and that no one is listening to her and everything like that. I am very glad that they did not resort to that. Yeah, right? Right? Yeah, they're in deep for that 7K. Yep. Oh, you poor thing. I just love that you're a lawyer and you still come and spend time watching me, even though this is what you have to deal with all day long. I absolutely adore you. Oh, God, Mortimer Duke. Oh, I love you, you crazy cat. Yes, we have like 4 more cases after this. It's a total of 2.5 hours because I love you all and I just kept finding better and better stuff. This was kind of one of my favorites though.
Ready? If you're ready, we can proceed. I've got Miss Collette here in the office here with me. She's here on other business as well. And Mr. Chillick. So I think we've got everyone. Before we begin, I want to tell you we've got an official court reporter here who's taking down everything that's being said, and she is making the only official record of these proceedings. The Texas Constitution requires that courts be open to the public. In an effort to comply with that requirement, we're also live streaming on YouTube channel Judge Jeff Duran. Because we are live streaming to the public, please don't give out any specific identifying information like street addresses, email addresses, full names of children, or telephone numbers. And Mr. Chillick, I guess we're here on your motion. Is that correct?
Yes, Your Honor. David
And
Chillick on behalf of.
This is CCL 2518730 in the matter of the marriage of Angela Brown and Christopher Brown. And Mr. Chillick.
Yes, Your Honor. David Chillick on behalf of the respondent, Christopher Allen Brown. We are appearing today via special appearance in this divorce matter that has been filed by the petitioner Angela Elizabeth Brown. And it is our position, Your Honor, that at the time of filing, Ms. Brown was not a resident of Anderson County, that she didn't meet the residency requirements. And as such, the court did not obtain jurisdiction at the time she filed. After on August 6th, we filed in Smith County a petition for divorce. We also obtained a temporary restraining order in Smith County. And so prior to the Anderson County obtaining jurisdiction over this matter and prior to her becoming a resident, we filed and Smith County obtained dominant jurisdiction of this matter. Additionally, Your Honor, we believe that venue in Smith County is proper. The parties have lived in Smith County until fairly recently for about 2 years.
Mr. Chillick, you're muted, it seems.
Hello?
Now we can hear you. Go ahead.
Okay. I'm sorry, what was the last thing you heard of my diatribe there?
And fairly recently.
Oh, you're talking about when they had moved to Smith County.
Yes, thank you, Honor.
Mhm.
So the parties have lived in Smith County along with the children for about 2 years, up until recently when Miss Brown vacated the home. So I think the venue is proper in Smith County because most of the contacts, most of the service providers, most of the community property in the state is going to be located in this county. And then lastly, Your Honor, I believe it's a more convenient forum. I believe most of the witnesses, most of the professionals, and again, most of the property is going to be here in Smith County. Lastly, Your Honor, I know this is a huge point of contention. I don't believe that Ms. Brown agreed to this. in any manner, but the children are currently attending Rice Elementary in Smith County. I know she's not on board for that, but they do attend that school. They're in school right now. And so that's our position to the court, Your Honor. I'm asking the court to dismiss the suit that was filed by Ms. Brown and allow the parties to continue forward in Smith County.
And Ms. Paulette,
Yes, Your
let
Honor.
me turn this around and say,
So my client does not dispute that for the last couple of years they had lived in Smith County. My client and Mr. Brown lived in Anderson County for an extended period prior to moving to Smith County. The child actually started school. We have a third grader and we have a little bitty one that's still in daycare. So unfortunately, Mr. Shellick's statement that both of the children are attending Rice Elementary is not accurate. There's only a third grader that's actually in public school. But I'll come back to that. But that child had actually started school originally in Westwood prior to moving. They moved up to Smith County and had lived in Smith County. I do have to contest that, the argument that most of their property is up in Smith County is kind of a wash, because my client has moved back down to Anderson County. She has lived in Anderson County since April the 4th. And the property that he's talking about is just personal effects and vehicles, because the parties are actually living, or were living, in an apartment there in Smith County. So the parties had lived there in Smith County, but my client moved to Anderson County on or before April the 5th. Your Honor, I'll proffer to you what I can mark as Petitioner's Exhibit 1, which is the receipt for the rent that she pays to her mother. It is not a deposit, Judge, and I can call my client to testify to these things as well, but for the sake of just being brief on this hearing alone, that receipt evidences that she started living in Anderson County on or before April the 5th. She moved in with her mother. The argument that most of the witnesses are going to be in Smith County is also not quite accurate, because my client's parents live here and Mr. Brown's parents live here. And so the only person that actually lives up in Smith County is Mr. Brown. And Mr. Brown is unemployed at this point, as far as I'm aware, unless he obtained employment within the last day or so. He was unemployed at the time that I spoke to Mr. Shellick last. My client is employed. My client moved here because this relationship became very abusive. The evidence will show, and I'm sure we'll save that evidence for.
Your Honor, I'm going to object to this part of the opening statement, Your Honor. This is getting into the thick of the case and kind of facts that are in dispute. So I would just object to it going into that measure of testimony.
Your Honor, I believe that part of the testimony and part of the opening is important, because if Mr. Shellick is arguing to the court that my client didn't move until a month after the date that she actually moved, the purpose of her moving, the domestic violence that was occurring, kind of prompted the move when the move happened. And so it is relevant that, to show that she moved when she moved, and that was the reason why she moved, was because he had become very abusive. My client's scared of him. And the client
I'm going to object again. They did not plead exigent circumstances. They did not ask for a protective order. And so I don't know where this is going, but this is not relevant to the issue of jurisdiction, residency, and venue.
I've read through both of your pleadings, did that yesterday, and my understanding of the issue is when the move actually occurred. And I understand your position is it was May 9th. And you've attached some emails or messaging back and forth. I don't think that's dispositive. I mean, it's not clear enough from those exchanges that the move hadn't occurred already when those were exchanged. So I would like some corroborating evidence on that. And
Yes.
if that in fact is disputed.
Yes, Your Honor. If I may call my client.
Have you finished your whatever you're going to say?
I can be.
Okay.
I can keep going either way.
Yes, no objections to that exhibit. I believe that's the rental check or receipt you sent me. Is that right, Ms. Collette?
It is.
Okay, no objections to that, Your Honor.
Very well, it's received.
Thank you, Your Honor. Mr. Brown, can you please unmute yourself and state your name for the record?
Hello, Christopher Allen Brown.
And you're currently married to Miss Brown, correct?
Yes, I am.
And the two children subject to the suit are both you and Miss Brown's children, correct?
Yes,
And where do you currently reside?
I reside in Smith County.
And how long have you resided there?
I've been living here since March 2023.
How long have the children resided in Smith?
They have been here the same amount of time.
Do you currently occupy an apartment?
Yes,
Whose names are on the lease?
my name and Angela's as well.
And where does Miss Brown work?
Miss Brown works at Tyler Periodontics here in Tyler, Texas.
All right. When did Miss Brown move out of the residence there?
Miss Brown moved out on May 9th of this year.
And as far as May 9th, we've attached 2 text messages to our special appearance as Exhibit A and Exhibit B. Are you familiar with those text messages?
Yes, sir.
Are they true and accurate?
They are true and accurate.
Your Honor, I'd offer those in as Exhibit A and Exhibit B.
Ms. Collette?
Mr. Chillick, can you designate which one is A and which one is B?
Yes, I'll separate. Well,
If I recall, the first one was dated May 9th, and the second one was dated May 14th.
that's correct, Your Honor.
Okay.
Your Honor, my issue with that is that one of the text messages is between Mr. Brown and another party. One of them is between Mr. Brown and my client. And so I would object as to hearsay for the one that is between him and another party.
I didn't
Or not a party, another person, a third party.
I didn't submit that one, Ms. Collette.
Okay, then I don't know if I've seen what you have.
Let me see if I can pull it out.
Both of these messages are between the parties.
Maybe you could clarify for me, there's a gray one, a gray bubble. Well, let me see. A gray bubble and a blue bubble, if I recall. I haven't got it yet.
Yes, Your Honor. So the blue bubbles are my client, Christopher Brown, and the gray bubbles are Miss Brown.
Okay. Okay. These are the two, and the first one's marked Exhibit A.
Josh, do you mind if I get up and
Not at
your
all.
shoulder?
Not at all.
Okay, I had not seen that one.
This is attached as an exhibit to the motion. So he's the blue, I guess, and she's the,
Okay.
okay. And then B is from the 15th. It's May 15th.
Okay, no objection to those.
Okay. Without objection, respondents 1 and 2 are admitted.
Thank you, Your Honor.
Mhm.
And so, Mr. Brown, on Exhibit A from May 9th, essentially, you have a communication with your wife about her moving. Is that correct?
Yes, sir.
And at 22:32 p.m., Miss Brown states, "I'm unpacked, minus the one big suitcase because I don't have anywhere to hang my clothes yet or set my shoes," correct?
Yes.
And what was she talking about as far as the suitcase?
She was just arriving that day at the address with her things because she moved out that day. So that was her just letting me know that she's unpacking.
All right. And was that the first time that she had actually moved into wherever she was going to reside?
Yes. I
Please-
do have a record of her staying a night with her father, but not
Objection,
living.
objection, non-responsive.
Sustained.
If you'll let me ask the questions, Mr. Brown.
He just had to call objection non-responsive on his own client. Oh my goodness.
Yeah.
And just answer the questions. Thank you. So Exhibit B is from May 15th at 9:20. Do you recall that communication with your wife?
Yes, sir.
She states she's putting in a Walmart order tomorrow to be delivered to my dad's, correct?
Correct.
And that was about a week after you stated that she moved out. Is that correct?
Yes.
And then on the second page of that exhibit in the second to last message sent by Miss Brown, she states, "It's only been a week. Give me time. Give yourself time." Correct?
Yes.
Is she referring to she's only been moved out for a week?
Yes.
Objection calls for speculation.
Sustained.
Okay. Now, Miss Brown alleges or purports that she moved out of the marital residence and moved into Anderson County April 4th or 5th. Is that your understanding?
I assume that's the understanding. This is the first time I've heard of it, sir.
Is that true? Did she move out of the marital residence in April?
No.
Where was she spending the nights during that time period from April to May 9th?
She was spending them at my home. Our
During
home.
During that time, did y'all ever do exchanges of the children, or did you take the children over to her grandparent or to her parents' house for her periods of possession?
I do believe the children may have stayed with grandparents on occasion, but during that time frame, Angela was still with me.
Okay, so it wasn't as though she was with the children at one of her parents' homes, correct?
Correct.
Now, the rent receipt that was provided as I think it's Exhibit 1, have you had occasion to see that rent receipt?
Yes, sir.
Had you ever seen that before?
No.
Do you recognize who signed the rent receipt?
Yes.
Who was that?
I believe off memory, I can double check right now. It was Angela's mother.
Now, at any time from April 1st to present, has Miss Brown resided with her mother?
No.
Who did she start residing with on May 9th?
She moved in with her father.
All right. Now, when she did move out, whenever that date was, you purported May 9th, did y'all make any plans for possession access for the children?
Our plans were during the summer, 7 days each, and during the school year, we talked about Monday through Friday with me.
Now, for the summer, did y'all hold true to that 7 days on, 7 days off schedule?
The schedule was in place. I did maintain the kids more due to requests being made to me to keep the children longer than my 7-day period.
Okay. Did you withhold them from her and just
At no point have I withheld the children.
do both children attend Rice Elementary?
They do. Both of them currently.
Aside from personal effects and vehicles and some retirement accounts, do y'all have any other property of value, real value?
No.
Pass the witness, Your Honor.
Ms. Collette,
I didn't get his answer.
he said no.
No questions with this witness, Judge.
Okay, Mr. Chillick?
That's all I have, Your Honor. I'll reserve my questions for Ms. Brown if she's called, and then closing.
Very well. Ms. Collette?
I'd like to call Miss Brown.
Okay,
Miss Brown, can you hear me?
let me ask her to, there you go. Okay.
Can you hear me?
Yes, ma'am.
Okay. Can you please go ahead and state your name for the record?
Angela Brown.
And Miss Brown, you're currently married to Chris Brown, is that correct?
Yes, it is.
Okay, and you understand that we're here today on Mr. Brown's motion for special appearance. He's disputing the time that you actually lived in Palestine. You understand that, correct?
Yes, ma'am, I do.
I actually kind of really love that this case is by special appearance and about jurisdiction, and it's nothing to do with the soft sit.
Okay, when did you start living in Palestine?
I started staying in Palestine in April. How I did not go get the bulk of my things until May.
Okay, when you start, like, you have a receipt that's been marked as Exhibit 1. That receipt was to your mother. Why did you pay your mother, or did you pay your mother $400 to be able to live with her?
Yes, I had been staying with her and I wanted to replace groceries and utilities and other things that she had helped me with at that time in April.
Okay, so had you actually been living with your mother prior to the money being paid and the receipt being given?
Here and there, but not fully.
Okay, And was it on or around April the 5th that you started living here full time?
Yes, ma'am.
Okay. And would you say, how many nights a week would you say that you were staying with mother in April?
With the exception of a few days here and there for certain things, like a kid being sick or needing to be in Tyler for any reason, full time.
Okay. And so it's your position that you took up full-time residence in Palestine in April or April 5th of this year?
Yes, ma'am.
Okay. And have you looked at trying to enroll the children in school here?
Yes, I have tried on multiple occasions, but with 100% refusal from my spouse.
Okay. Tell me a little bit more about that. What do you mean he's refused?
That I'm not allowed to. That no matter how many times I've motioned to him that I think them being here with me and the 4 of their grandparents to help with school, he completely disagrees and says they will not go to school here, that they will stay with him and he will have Monday through Friday.
Okay. Was it y'all's agreement that he would have Monday through Friday, or is that his statement?
That is his proposition.
And do you agree with that?
No, that is not fair to me. That is not me getting my time owed with my children.
Okay. And do you believe that it's in your children's best interest for Mr. Brown to have every Monday through Friday?
No, it is not.
Do you believe that you could pick up your children right now and bring them, to your residence with, is that a possibility?
Yeah, if I wanted to go pick them up from school right now, I could.
But before they actually started school, and they started yesterday, right?
Yes, they did.
Okay. So before they actually started school, do you think that you could have picked them up and brought them to your residence and had them enrolled in Westwood?
No,
This calls for speculation, Your Honor.
And that's overruled.
You can go ahead and answer.
no, ma'am, he would not have allowed that.
Again, that's speculation, Your Honor, as to what my client would or would have not agreed to or done.
Has he told you that he wouldn't allow that?
We actually had some miscommunication a couple days ago on if he would allow me to.
Objection, non-responsive, Your Honor.
And that's sustained. Go ahead.
Has he told you that he would not allow you to take the children and put them in Westwood School?
Yes, ma'am, he has said that.
Okay. Has he told you that he is insistent that these children go to the school zone to where he's at?
Yes, ma'am, he has.
Has he refused to allow you to pick up the kids and take them to your residence for enrollment at Westwood?
Yes.
Okay. And so Mr. Brown's position is that you had stayed at the residence, or that you had lived at his residence until May the 9th. What was significant about May the 9th? Is that what happened? Like, is that when you went and got the rest of your things?
Yes, ma'am. That is whenever we had gotten all my boxes together, my suitcase packed, and the bulk of my things removed from the apartment was May 9th. However, I was staying in Palestine prior to that.
Okay. And did you just have a kind of a small collection of your things with you in Palestine prior to that?
Pretty much just enough to wear clothes and my work clothes for the week, but none of my, and hygiene stuff, but not like my actual things. All of that still remained at the apartment.
Okay. And was there a reason why you hadn't gotten all the rest of your things? Was it that Mr. Brown was always there, and that anytime, kind of what led to you leaving some of your things behind, essentially?
Really just finding a good time for both of us to sit through the apartment and decide what I would take, and just coordinate whenever we could be together cordially to go through that, and have me have some help putting boxes in my car, things like that.
Okay. And did you believe that, y'all finding some time that you could do this cordially was important?
Absolutely. I did not want it to be a matter of anger between us. I just wanted it to be peaceful, have a date set, and move on.
Okay. And is there a reason to believe that there would have been a matter of anger and turmoil?
I object. It calls for speculation.
Well, if I understand the question, it inquires into her sense, and I'll permit that.
You can go ahead and answer.
Yes, ma'am. Just, I didn't want it to turn into a screaming match between either of us because he did not approve of me leaving. He wanted me to stay.
Okay. And has he been aggressive with you in the past?
Yes, ma'am.
And was his aggression part of the reason that you decided to leave the residence?
Yes, ma'am, it was.
Has he put his hands on you in anger in the past?
I'm going to object to this line of questioning, Your Honor. Again, the pleadings don't have anything regarding physical violence or domestic violence. We're getting super far afield for this purpose of this hearing, Your Honor.
It goes as to her reason for leaving when she left.
I think they've established her allegations as to why she left.
And I'll sustain the objection.
So Mr. Brown's position is that you never lived with your mother. Is that true?
No, ma'am. I lived with my mother at first and did transition to my father's house because there was more space there for me and my.
I'm sorry, I'm going to have you repeat that again because for a second it seemed to have cut out, or at least my ears did. And so can you repeat that statement again?
I had started out at my mother's house, but then transitioned to my father's as there was more room for me and my children to reside there.
Okay, so about how long did you live at your mother's house before transitioning to your father's?
Roughly just the month of April.
Okay, and so about when or about did you move to father's house?
The May 9th discussion was me moving my things into my room at my father's.
When you lived at your mother's house, were you and the children in one room?
Yes, ma'am.
Okay, so is it fair to say that you didn't have a lot of room to bring the rest of your things to that one room where you and your children were?
I did not have any room to bring that stuff.
Okay, but when you moved to your father's house, you had more room and therefore more space to put your things. Is that accurate?
Yes, a room for my children and a room for myself to allow room for those things to bring.
Okay. So you lived does your father also live in Palestine?
Yes, they are both Anderson County residents.
Okay. Your Honor, I'll pass the witness.
Okay, Mr. Chillick.
Yes, Your Honor. Ms. Brown, you work in Tyler, correct?
Yes, I do.
And you work Monday through Friday, correct?
No, I work Monday through Thursday.
What is your schedule Monday through Thursday, 9 to 5?
No, I arrive at work at 7 and I don't 5.
Okay, so 7 to 5 Monday through Thursday?
7:30 to 5, give or take, yes, Monday through Thursday.
So you wouldn't even be able to pick up the children from school, regardless of where they are, correct?
I could leave work at any time I needed to.
Objection non-responsive, Your Honor.
The objection's overruled.
So you would not be able to pick up the children from school, no matter where they went to school, correct? Whether that be Smith or whether that be Anderson County, correct?
I would be able to.
You'd have to leave work early and pick them up and then go back to work? Is that what your testimony is?
Yes.
Okay. And you've cleared that through your boss?
Yes, sir.
And so if the children were in Rice, as they are, you would have to commute 2 hours, basically had to pick them up, drop them back off at your house in Anderson County, then go back to work, correct?
That would be a situation where I would have probably some of my parents help.
Okay, but your parents are not the parents of these children, correct?
No,
And you and my client are the parents of these children, right?
correct.
All right. So as far as the bulk of the things, you said we had to get time to pack things up. And when you say we, you and my client were actually packing your things, correct?
Yes,
So it could not have been that volatile if my client was helping you pack your stuff, correct?
I disagree.
Now, this past weekend, you had the children, correct?
Yes,
And you actually brought them back early to my client, correct?
they had asked.
Objection non-responsive.
Sustained.
You can just answer the question, Ms. Brown.
Yes,
And that's because they wanted to come back to my client's home early, correct?
Yes.
Objection calls for speculation.
And the objection's overruled. She's answered the question.
And so y'all are working pretty well as in regards to children and possession access, correct? In that regard.
Yes, we are.
All right. Now, you referenced you moved out April 4th. How do you know you moved out April 4th? Tell me how you moved out. Like how you know it's April 4th.
Because that's whenever I wanted to go ahead and give my mom some funds for the anticipation that I was going to be staying with her for April.
I understand the anticipation. So was it a deposit on future rent? Is that kind of what it was?
It was just more so, hey, I'm going to need some resources. Here's some money.
So resources, but not technically rent, correct? You hadn't moved in there April 4th, correct?
I had already started staying, yes.
Staying, but not living there, right? That's two different things, right?
Sure.
And during that time, you were still spending the night at your marital residence with the children and my client, correct?
No.
All right. Now, as far as the home at your mother's house, you said you lived there in April. Is that correct?
For most of April, yes.
But not all of April, right?
With the exception of some days, I'm sure.
Some days you spent at my client's home, correct?
Yes.
And you didn't have enough space in the home, so you left the children there at the marital residence, right?
They were going to school still.
What do you mean?
They were still enrolled in Rice.
I wouldn't care. If my partner was abusive, I would take my children. I would enroll them in a different school. It doesn't take that long to do that. You have a little bit of time. If your partner is abusive, you don't leave your children with them. It makes me question so much of everything with this woman, and the receipt for rent to her mother. Yeah, no mommy in the world is going to write out a receipt for their dear little daughter when they're in a custody dispute. That wouldn't be a thing. There's no dishonesty in this world.
Oh, so they were already enrolled in Rice.
Yeah, April is still considered during the school year.
So they were already, the oldest was attending Rice this year?
Yes, this year will be her second year at Rice.
So what was the disagreement about enrolling? Because she was already enrolled, correct?
No, this is April of 2025. Then was the summer. You still have to re-enroll for the next following school year.
She had already gone to Rice Elementary in 2025, correct?
Yes.
And you wanted to unenroll her and put her in Anderson County schools, correct?
I wanted her to start the school year.
Objection non-responsive, Your Honor.
Overruled.
So you wanted to unenroll her and put her in an Anderson County school, correct?
I wanted her to start August school year of the next following school year, 3rd grade, in an Anderson County school. Yes.
Because that was more convenient for you because you have your parents there and that's where you were going to intend to live, correct?
Yes.
So how does that benefit the child?
First of all, childcare.
Okay. My client worked from home, correct?
Yes, but that's not guaranteed. He
All
doesn't.
right. Absent that, what other benefits to the child? How does that serve your daughter's best interest?
Because she's closer to the majority of her family.
Shouldn't she be closer to her father?
I would argue that it's in her benefit to be close to both of her parents.
All right. And you moved out, correct?
Yes.
All right. I'll pass the witness, Your Honor.
Ms. Collins?
Just real briefly, Ms. Brown, were you living in Anderson County at the time that you gave receipt to your mother for living at her residence?
Yes.
And absent a few days here and there, have you continuously resided in Anderson County since on or before April the 5th of 2025?
Yes.
And At the time that we filed suit, on August the 4th, had you been living in Anderson County for at least 90 days?
Yes, ma'am.
Nothing further, Your Honor.
Mr. Chillick?
Very briefly, Your Honor.
Sure.
Ms. Brown, in your petition for divorce filed in Anderson County, you stated that the date you separated from my client was April 10th. Are you aware of that?
Yes.
So you couldn't have moved out until April 10th, right? Because you were
We
still with my client, correct?
I moved out and we had agreed to separate.
Okay, so the pleadings are incorrect. Is that what you're saying?
I moved out and we agreed to separate a few days later.
Okay. Now, last point here. Why did you get a receipt from your mom for rent in April?
Because I had given her cash
Why did you need a receipt?
for a situation like this.
You got the receipt for purposes of this situation, correct?
Just anything that I would have needed it for.
What other things would you have needed it for?
Possibly school enrollment, things like that.
Okay. Do you have your driver's license?
Yes, I do.
Can you pull it out and show me the address on it real quick?
Judge, I'm going to object to showing her driver's license on a Zoom.
Yeah, we're live streaming, so I'm going to sustain the objection.
I'll withdraw the question, Your Honor. Isn't
Very
it true
well.
you haven't changed your address on your license, correct?
I'm sorry, what?
You have not changed your address on your license, correct?
No.
All right, pass the witness, Your Honor.
Ms. Collette?
I just need to see if her mother is available. I think that her mother was supposed to be available. Is Angela, is your mom available?
Yes, she is.
No further questions with this witness then, Judge.
Okay, your next witness.
I'll call my client's mother. I believe her name is Sandra.
Yes.
Your Honor, I'm going to object to this witness. Had I known that there were witnesses other than the parties present, I would have invoked the rule. As such, this witness has heard all of this testimony. She's been in the room, obviously. So I strenuously object to this witness for this stage of the process, Your Honor.
Your Honor, he had the opportunity to invoke the rule if he wanted to invoke the rule, and that would have had the result of clearing out the room if he felt that that was necessary.
I didn't know we'd have third-party witnesses
Right.
present.
Sorry, I didn't mean that.
Judge, a third party could have been listening on Zoom. Like, this is a public hearing. There's every reason to believe that even if she hadn't been present in the room, she could have been logged on to the Zoom. So she still would have been present.
I should have been afforded the opportunity to invoke the rule or know that there was another person aside from the parties testifying at a special appearance, Your Honor. I think it's unusual to have a third party testifying at a special appearance. That's my point.
Judge, you announced that it was a public hearing and that it was on Zoom. There is a presumption that with it being a public hearing, that other people could or would hear this hearing. And so my witness should be able to testify.
There's a presumption that uninterested parties would hear it, Your Honor, but not parties or people that have an interest in the suit or could be potential witnesses. That's a big difference.
Sorry, the Zoom link does not only go, the Judge Duran's channel is not only limited to, those not interested in the case.
I have to tell you, I don't go viral. So it's not, I think I have 150 followers.
I think that my husband is one of them.
And so it's not a huge thing. It's not monetized. I assume this witness is going to corroborate the testimony of Miss Brown.
Yes, Your Honor. And I mean, she was where my client was living.
Right.
And so, and it's actually her signature on the receipt. So, and her writing on the receipt. So it only follows that she would be there to admit this piece of evidence.
Well, I'll observe. Yeah, I'll observe at this point that the testimony concerning the receipt has not been impeached. And so the objection sustained.
I'm sorry, I'm trying to understand the objection to this witness being able to testify.
Yeah.
So, Judge, if I may ask for the court to reconsider that one.
I'm just saying, The receipt has not been
Right, but
impeached.
as far as the receipt, I understand, but my client's witness would be able to testify about when she actually started living there, not just about the receipt itself. But my argument in bringing forward the receipt is that opposing counsel cannot say that he was surprised by the appearance of
Sure.
this witness when the receipt was provided to him prior to this hearing, and he would have anticipated that her testimony would be necessary to bring this receipt into testimony. So
Here's what I'll do on that. If Mr. Chick presents evidence that disputes the earlier date, then I'll permit her to respond to that to corroborate the testimony. But at this point, Mr. Chillick's objection is sustained.
and he's already rested, and so if that's
He gets rebuttal though.
okay,
I mean-
so I'll pass for this moment
Okay.
and save rebuttal.
Mr. Chillick, you get the last word. Anything further?
Yes, Your Honor. Just as a closing, Your Honor, can I give my closing at this time, Your Honor?
Sure, go ahead.
Thank you, Judge. Thank you for accommodating us today as well. But in closing, I think it's pretty clear, Your Honor, that Ms. Brown's date as to when she actually moved out of the residence is not a concrete date. I heard April 4th. I heard April 10th. The pleading says April 10th. My client has stated and has corroborating text messages that took place at the times of the events showing that she admitted she had moved out a week prior on May 15th. And then on May 9th, she was just unloading her suitcase at wherever she was residing, Your Honor. And I would just point out, Your Honor, that Texas Family Code 6.301 states that a divorce filing may not be instituted in the state unless the person is a resident of the county for the preceding 90-day period, Your Honor. Additionally, Your Honor, if it's their point that Ms. Brown had two residences, in order for her to prove that she had used the Anderson County as her residence, she would need to show that it was a more than a temporary arrangement. She would need to show the court that she intended to reside there permanently. I think the testimony has showed that the only thing that she has that she's presented to the court at least is one receipt that was signed by her mother, a very interested party. And she hasn't changed her address on her license. So there's nothing else that ties her to Anderson County aside from a receipt. So, Your Honor, it's our position that the move out date was May 9th. I think that she tried her best to, for purposes of litigation, show that she moved out on that date prior so that she could establish in Anderson County. But I think additionally, Your Honor, even if the court found that it may have jurisdiction over this case, I think Smith County is a more convenient and more proper venue and forum for this case. The child had already been already attending Rice Elementary this year and was already going to be considerably going to Rice again this semester, which she is now. The parties have lived in Smith County for 2 years prior to us filing this suit. And so, I think that testimony was also that most of their property, which is just personal items and vehicles, is here in Smith County, Your Honor. So it would be our position that, the Anderson County did not obtain jurisdiction because she wasn't a resident for 90 days preceding the filing. And then additionally, the venue is proper in Smith County and it's a more convenient forum for this case, Your Honor. Thank you for your time.
Ms. Collette.
Your Honor, my client's testimony establishes that she lived in Anderson County even prior to the receipt. The receipt shows that she is a resident of her mother's house on or around April the 5th. She did not move all of her belongings, and her domicile is not established by when she moved her very last bag. Her domicile is established by when she takes up residence full-time in another county and when it is her intent for that other county to become her permanent residence. She's from Anderson County. All of the grandparents, not just her parents, but all of the grandparents live in Anderson County. So the support system for these children is in Anderson County. It is my client's intent to remain in Anderson County. It was my client's intent for the child or children to start school in Anderson County, and they would have had it not been for Mr. Brown's refusal to allow such. Your Honor, the family code is pretty clear that, and the rules of Texas procedure are also very clear, that whoever files first chooses the venue. And my client filed first. And so for that reason, the special appearance and the motion to dismiss should be denied.
And Mr. Chillick?
Yes, Your Honor. So again, Ms. Brown's controverted testimony was that she lived part-time in Anderson County for the month of April. So she wasn't a full-time resident. Again, and she didn't take any other additional measures to change her residency over to Anderson County. According to the state of Texas, she still lives in Smith County. She works in Smith County. She travels to Tyler Monday through Thursday, which she testified to. And the grandparents are not parties to this suit, Your Honor. It's my client, Miss Brown, and these two children that are parties to this suit. And so, Your Honor, again, I don't believe that she was a resident of this county, of Anderson County, for the 90-day period preceding her filing. And additionally, there is some case law out there, Your Honor, that states if a party did file first, but used some questionable methods to file in that county, then that case can be set aside and the case can proceed in the second filed case. And it, again, Your Honor, it's our testimony and our position that when we filed in Smith County, prior to her curing the residency issue, Smith County became the dominant jurisdiction of this case. And I do believe it's a more convenient forum for these children and for the parties, since Ms. Brown already works here every day, pretty much. Thank you, Judge.
Sure. Let's talk about the practical aspects of this. This could go two ways. The motion could be granted. In that case, I'm assuming the court in Smith County would take over. Or if it's denied, tell me what you think would happen as a result of that.
Your Honor, if the motion is denied, it's my understanding from conversations with Mr. Chillick that he would be agreeing to the extension of the TRO already signed by this court so that we could reset this hearing that's scheduled for this afternoon to another date because Mr. Chillick is not available this afternoon.
And Mr. Chillick?
Yes, Your Honor, Ms. Collette did state that correctly. I don't have any affirmative pleadings on file with the court. I would not be able to proceed this afternoon. However, if my motion is granted and the case is dismissed, we are already set for temporary orders hearing here in Smith County, Your Honor. And so that case can go forward. It's already set far enough out. I believe that Ms. Collette and her client will be able to kind of hit the ground running. It's set on the 27th. And so I think it dovetails nicely where there won't be any prejudice to Ms. Colette's client in this case.
Your Honor, I have to disagree with that. I do not work in Smith County. As the court is aware, I live in Conroe. I do not take cases in Smith County. So if this motion is granted and Anderson County denies jurisdiction, then my client is actually denied her opportunity to have the attorney that she has hired to pursue this case further because I can't go to Smith County. And additionally, the day that Mr. Chillick has a hearing set, I'm actually already scheduled for a full day of mediation in another case. And so even if I wanted to, I couldn't attend the hearing that he's already got scheduled in the other case. But for Anderson County not to exercise jurisdiction, as jurisdiction is proper here. But if Anderson County were not to exercise jurisdiction, then my client is out all the money that she's paid to retain me and for the work that I've done. And she's going to be prejudiced by the fact that she's going to have to go and find somebody else.
And Mr. Chillick, it's your motion. You get the last word.
Yes, Your Honor. So Smith County is just as proper for jurisdiction in this case. I do believe that it's a more convenient forum for the parties, for the children. The children are already going to school and have gone to school here in Smith County. Presumably, we may have teachers and administrators come in and testify. Anderson County is a jaunt. I don't really practice out there that often, Your Honor. I think the last time I was in Anderson was 3 years ago, maybe 2 years ago. And so I understand that she may have to hire new counsel, but I will, the case is set out far enough in advance where we can get that done. and I'll work with her, whoever her new counsel is, to make sure that they have time needed to prepare for a temporary orders hearing.
All right, very well. Thank you, counselors. I'll make a finding that that the petitioner in this case, a respondent in the Smith County case, established residence in Anderson County on or before April 10th. Based on that finding, the motion to dismiss is denied respectfully. All right, good luck to you, folks.
Your Honor, while we still have everybody
Yeah.
present, since we are going to have to agree to an extension of the TRO to allow Mr. Chillick more time for this to be rescheduled, can we go ahead and get Mr. Brown sworn to reappear at that or something, you know, kind of, I don't know if we need to pull Elizabeth in to try to get a date for that maybe, but I just want to make sure that we go ahead and nail down that there is going to be an extension of the TRO already in place.
Elizabeth?
And I'll accept service of the TRO extension, Your Honor, on the record on behalf of my client. There's no need to order him back or anything like that.
Okay, great. Anything else?
That's it, Judge. I just
All
wanted
right,
to make sure.
Mr.
that we
Chillick,
know.
anything else?
No, Your Honor, I'll submit an order. I appreciate the court's time again. Thank you.
Absolutely. Good luck to you, folks.
Thank you, Judge.
Thank you.
So his lawyer doesn't want to travel to that county, and her lawyer absolutely doesn't practice in the county that his lawyer wants the venue changed to. And also, his lawyer wants to reschedule the next court date because he can't make it. And there's already one scheduled in his county, but that date, her lawyer can't make it under any circumstances. Oh, my mess. Oh, I don't know. It was a special setting. It was kind of like an emergency hearing. I don't know how appeals work on that in that case. It kind of seemed like that. I honestly wonder if it was more about the lawyers' conveniences than it was about their clients and the children. The whole changing venue thing, it just seemed like the lawyers had more skin in the game for it than the parents. So Mr. Mustache is the one that brought the motion for change of venue to the court in the first place. The motion was denied. So technically, mom's lawyer won that the case stays in the current venue. I don't understand. Yeah, I mean, I get that. I get that. I don't know everything about lawyering that you know. I've picked up a few things here and there, but you are definitely way more qualified than I am. Shh, don't tell my friends. All right, guys, let's go on to the next one.
I'm going to end this now.
This is the matter of Manor Born Limited versus Infinity Ryan, 25-02012. Councilman Ferris, please.
Good afternoon, Judge. Mark Wasbury for plaintiff.
Who's Infinity Ryan? You can come up to the camera, please. State your name, ma'am. Infinity Ryan. Okay, today was the date that was scheduled for a motion. I believe this is the plaintiff's motion for order of eviction. Is that accurate, Mr. Wasbury?
Yes, Judge.
Okay, and the court has reviewed the motion and you're requesting for order of eviction, but it's beyond the 56-day rule.
Yes.
And the 56 days was not addressed when you entered your consent judgment, I don't believe.
Correct.
And waive the 56. Did you enter a consent judgment, ma'am, at the previously on this case? Do you recall? Okay. Let me pull it up. Okay, I do see a consent judgment, and you were supposed to pay $2,515.09 by June 2nd, or vacate the property by then? Yes. Did you do that? No. Okay. But it looks like your client, Mr. Rosary, must have granted some additional time or something. I'm not sure why there was a request made.
I think I think Ms. Ryan has been in touch with the management office trying to resolve this, but we've received no payment since the judgment.
What's going on, ma'am?
So, I wasn't employed, and I've actually just got a job. So basically, Pam, she's telling me that she was going to recalculate because I was able to show her proof of some of the months that I'm getting charged for that I was not working. So she told me that she was going to recalculate everything and come and talk to me about it to see about the payment plan.
Who's Pam?
She's the manager from Fender.
Okay, this is subsidized housing?
Yes.
Okay, so you weren't employed, so you're saying that your rent should have been zero during those times? Mr. Wassery, were you aware of that?
No, Judge, she said she signed a consent judgment. Pamela Payne is the property manager. She did try to zoom in, but then got kicked off. Can I ask her to try to zoom back in, Your Honor?
Absolutely.
Thank you. I'm gonna mute myself and ask her to do that. Thank you.
Am I able to have someone else talk?
If you want, if we proceed with the hearing, you can call a witness. Okay, you can have a seat while I move on to the next case until he can get someone logged in, I guess. That's fine. Mr. Wassery is fine and logged in, or? Okay, I see it. Okay, back on the record, and this is on the matter of Manorborn versus Infinity Ryan. Mr. Wassery, you wanted your client to log in. I don't know if that was to address whether or not she was asking, or whether or not what Miss Infinity said was accurate, because Miss Infinity has stated on the record here that Pamela, and I'm assuming that's Pamela Payne, advised her that she was going to meet with her to agree to go over her rent and what she should have been assessed because she was unemployed, she believes, and that her rent should have been zero. So I don't know if that's accurate, and I don't even know what time frames that's for.
Yes, Judge, that's accurate. Ms. Ryan indicated that perhaps a recertification would have cured the issue or some of it, and I would like Ms. Payne to address that. Ms. Payne, can you hear us?
Yep, I can hear you now. I forgot I put headsets on.
Okay, we're addressing the recertification issue. Ms. Payne, Ms. Ryan thinks her rent should be lower because she was unemployed for some of the months.
Well, Miss Ryan never let us know that she was unemployed until 2 days ago. She never got us the paperwork for that. And then she said that she just started at Meyer Warehouse today.
Okay. Did you tell her that she can meet with you and you would go over her rent to be calculated?
I did. I talked to other management and they don't want to take her back that far.
I don't know what they're gonna do. Do you have any other testimony that you wanted Ms. Payne to provide at this time, Mr. Wasbury?
No, thank you, Judge.
And you wanted to call a witness, ma'am? Who are you calling? Your grandmother, what's her name?
Tanya Lauderdale.
Tanya Lauderdale, if you can come forward, please. You state your name first and last for the record. Tanya Lauderdale. Okay, so what is it that you wanted your grandmother to tell us? Or to testify about? Or what is it?
Okay, what happened is back in June 2nd.
This year?
Yes.
Okay.
Kennedy and I were on the phone with Pam. we called Pam to clarify because at first, back in, I want to say, August of 2024, Infinity was dealing with somebody named Tina that was the management of the office. And she sent in all her information stating that she wasn't no longer employed. And she.
Okay, so let me stop you. So you're saying prior to June, there was someone else other than
Yes.
Pam working there?
Yes, her name
Okay.
is Tina.
And so Infinity was dealing with Tina then, okay?
Yes. And she told Infinity that, she told Tina that she was no longer employed at Amazon and she wasn't getting unemployment anymore. Now, right here, we have some paperwork that Infinity had sent stating, showing that she was no longer employed. I'm sorry, I had to print this off on the cardboard. But right here shows right here where it says that she wasn't working at Amazon. She was employed on August 2020.
What is this paperwork that you have here? What is that?
This is something that Infinity had originally gave to Tina.
Well, what is it though? Is it?
Oh, it's showing.
Is it an email? Is it a screenshot? What is it?
Yeah, it's a screenshot.
Screenshot of what?
Of her information that she gave Tina, showing that she was the time that
Oh,
she worked
okay.
at Amazon and when she didn't work there anymore, showing that she didn't have an income.
She physically handed this over to
Tina.
What day was that? Do you know? Do you know it, Mom?
It was before September, because I remember I'm the one, because I help her out all the time.
Before September of 2024.
Yes, it was in September of 2024.
Right. She asked me to show her the proof of my unemployment and stuff.
And we had
I moved in using unemployment.
You moved in using unemployment. Okay. And then when you no longer was receiving unemployment, you say you advised someone named Tina.
Yes, she's.
And what is it? What do you have that you advised her? Let me see.
The unemployment showing on the one with the blue at the top. That's showing when the unemployment expired.
Do you have any other screenshots of communications prior to this? Or any communications with Tina?
I didn't.
So you didn't print them with Tina? You still have them in your email? Can you pull them up?
And this one right here is when she was out with Amazon, and it shows when she was done working with them. She's saying that she just talked to Pam. Pam said she just talked to her 2 days ago. Well, we got a date right here showing her talking to Pam on June 2nd. So, and Pam tells her to come into the office to fill out the necessary paperwork, which was the paperwork showing the breakdown of not having income. She was supposed to go back and recalculate.
Do you have messages from Tina with communications with the Tina?
Yeah, this is, the other email is still loading, but you can see it's starting to load where I emailed her 11/11/2024 and let her know that I need to come in to the
recertification.
But it's still loading, she said.
11/11/2024, Tina Sheldon. I don't have any income at the moment. Did Tina Sheldon work for your client, Mr. Wasbury?
She did at one time. Is that an email, Your Honor?
That is an email to Tina Sheldon at presmanagement.com.
Yeah, she did at one time.
Yeah, this is a communication between her and Tina from November of 2024. So your client was notified that she was unemployed.
Well,
And
Judge,
so this is a common issue that we're seeing in the court where changes of management is becoming a problem. And the tenants are the ones who are being disadvantaged. She shouldn't be disadvantaged because management was changed and those emails and communication was not provided to whoever took over in her stead. She notified them that she didn't have any income. And it looks like she provided information. She has copies of the information that she provided showing that her unemployment was she no longer was receiving it. And so if Ms. Payne has indicated that she can come in and have that worked out, and it should be worked out, and she should be credited back to when she notified you all that she was not employed. Outside of that, you've already blown the 56-day rule, so I'm not issuing a writ. Definitely wouldn't issue it after this because she's already been disadvantaged because she did notify her landlord that she was not employed. And so her rent should have been adjusted.
Well, Judge, there's a process. She should have come in, that we need to verify that. There's a verification process.
She's showing me in court what she brought in and gave to Tina Sheldon. She's got copies of it here in court.
Okay, well, okay, Judge, I object because the time for trial was May 21st when we were in court.
Well, the objection's overruled. You're asking for me to to blow the time for you to get a writ, which was 56 days. You know what the rule is. She never waived that rule, and she was disadvantaged.
Well, she'll have to come into the
Whether
office.
or not she demanding a trial does not mean that you get to your rights. Not demanding a trial doesn't mean that her rights shouldn't be upheld. If she had the right to have her rent adjusted, it should be adjusted, whether she had a trial or not. And you and your client should want to do the right thing and get it cleared up. She notified Tina Sheldon at least in November, because she has emails to prove it, that she was not employed. There was a response back from Tina, and she has copies of the information she provided Tina to prove that she was not receiving employment. The whole purpose of the low-income housing is for the advantage of these tenants who are in those positions. And to now try to squeeze money out of her that she doesn't even have, she's already on low-income housing and she's been unemployed, that's unconscionable to me. So I don't care that it's not the time for the trial. I would expect that you would want your client to fix this, and you're not getting a writ because it's beyond the time frame to get a writ. Any additional matters for the record?
No, thank you, Judge.
Thank you. You're all set.
Ooh, did everybody hear that? Anybody else catch that? I deliberately didn't make a really loud crack because some people listen with headphones and I really didn't want to hurt their ears, but y'all know what that would have sounded like. Yes. Yeah. Yeah, in this case, it's not low income, it's no income, but yeah. Oh, I've got another one. Just you wait. A bench slap. Ooh, I need to get me a gavel. I need to get me a gavel, but I need it padded because I want to be able to, but I don't want to hurt people's heads. Oh, she was pissed. I don't think she was mad about the management changes. She was mad about the lack of accountability and about how management didn't keep up with the situation. It's not the girl's fault that, however, what was it, Tina left the job. It wasn't the girl's fault that happened. The information of that situation or the paperwork should have been filed. Why wasn't the paperwork in her folder? Maybe that's why that Tina girl lost her job. We don't know. But the problem wasn't the management change. The problem was the lack of information changing hands.
You don't have to know. She's going to need to work with their landlord to get that situation taken care of, because they have the right to restart this eviction, but they don't have the right to charge you for rent that you should have not been charged for in the first place. And this is the reason why we play this video that people don't want to pay attention for. I had a note in my system where you left court and refused to meet with legal services, and you were out of order for that. And you waived your rights and entered into an agreement to pay some rent that you probably didn't even know. So you need to do better to take care of yourself. You're adult enough to do that. If there's resources being provided here, you need to take them. If we ask you, you want to meet with legal services? Yes, I want to meet with legal services because I believe my rent should have been zero. That's what you should have been doing. So you need to go and try to go in person and try to meet with Ms. Pamela Payne, see if you can get this corrected, get the past due rent paid so that they don't reissue a eviction proceeding because they have to start it all over now against you so you can maintain your housing and a roof over your head. And then after you do that, you keep a record to inform yourself that you did it. Even if that means you send an email to Ms. Payne, just following up for the conversation we just had in person, this is what happened. You understand that? Do you have any questions? You're all set. Thank you. Let's see, Dorado is here. Who's here for Highland Flats? Okay, there's no attorney here for Highland Flats. Is this Brian? No, it's not. It's a D5. On the record in the matter of Highland Flats versus Honeycutt 25-03444 LP. Council can have your appearance, please.
Good afternoon, Your Honor. Attorney Hamza Sob on behalf of the plaintiff.
And I see Harley Honeycutt and Angelica Brito. If you can unmute and state your name for the record.
Angelica Brito.
My name's Hartley Honeycutt.
Okay, this was a motion to set aside dismissal and reinstate case. It says plaintiff filed a complaint on June 18, 2025 for the property in question. There was a hearing back on July 23rd for non-payment of rent before this court. The hearing was scheduled at 3:30. Counsel for the plaintiff did Zoom in for the hearing on the correct date and did check in with the court. However, after waiting in the waiting room in courtroom, counsel for the plaintiff got disconnected from the virtual court hearing after 20 minutes of trying. Counsel and plaintiff was unable to reconnect, but was advised by the court clerk that the case was dismissed without prejudice. The plaintiff's knowledge, the defendant remains in the home to this date and currently owes $2,597 in unpaid rent. Did I miss anything of importance in your motion? And
No, Your Honor. I think that's perfect.
okay. Help me understand why you would be in my Zoom room for a hearing.
I believe it was a Zoom hearing or a mistake of a Zoom hearing.
I don't hold hearings via Zoom for landlord tenant. You had to, that's in person only. I say that like a broken record at the pre-trial.
I understand that, Your Honor. I'm always in the 54A. I believe one of my colleagues had a scheduling conflict and he appeared via Zoom. And then he was the one that got disconnected. Sorry?
Oh, no, absolutely not. Mr. Asphalt, who was here, and you just refreshed my recollection. I know why the case was dismissed. Mr. Asphalt was here. Mr. Asphalt handled the hearing and then he left. Mr. Asphalt got into a vehicle and started driving and tried to log in and pretend like he couldn't hear the court because he was driving while into the court. And this is after I've already had the same issue with Mr. Asphalt by driving and trying to operate Zoom, which is against the law. And he lied then. And so this time he got disconnected. He did not have a good signal because he's moving in a motor vehicle during the time. So the case was dismissed. He had no authority from the court to appear via Zoom for said hearing because all my hearings are in person. He also had already had an issue with this court about appearing while driving a vehicle. I do not let anyone, especially litigants, appear while they're driving a car. And I'd expect an attorney who has a bar license to know better. So the case was dismissed because he failed to appear for court. So he can reissue the case and start from scratch. Maybe he'll learn how to follow the law in the courtroom.
I understand. Thank you, Your Honor.
Thank you. You're all set. Ms. Brito, Mr. Honeycutt, you're free to go.
Thank you, ma'am.
Thank you, Your Honor.
Thank you.
Oh, another glorious smackdown. A bench slap, as I've learned.
Johnson, do you have your suit coat on over a t-shirt?
Absolutely not. Do you own a suit? Where's your tie?
Well, I don't have one at the office like you do.
This is a special wear from New York.
See that?
It'll be just a few minutes. Judge Thornton's reading through the stuff that was just filed.
Okay.
Thank you.
Did you file anything, John? I can't hear you.
Yes, I just e-filed it and I emailed it to you.
Oh, good. Okay, I'm gonna grab it.
I'm going to warn you guys now, especially the ladies. Get ready to be very, very mad.
Can you hear me?
Ken.
Yes, Judge.
Good afternoon. Richland County District Court is now in session this August 15, 2025. Time is now 2:07 p.m. My name is Nick Thornton. I'm a district court judge for the Southeast Judicial District, which includes Richland County. We are taking up an emergency motion in Anderson v. Anderson, file 39, 2025 DM36. We're conducting today's hearing by reliable electronic means. We are live streaming today's event on the Southeast Judicial District's live stream YouTube channel. Any member of the public or media can attend these proceedings by following along in the live stream YouTube channel. Again, it's Anderson v. Anderson, 39, 2025 DM36. My camera is off because I am in a parking lot on my way down to Minneapolis, and I'm about halfway there. And as such, my camera is off. I'm not dressed appropriately in terms of being robed under Rule 10.1 of the North Dakota Rules of Court. The court notes Attorney Jonathan Green is present by reliable electronic means. Attorney Sam Johnson is present by reliable electronic means. Do I have any parties that are appearing?
Yes, Your Honor. My client, Ark Anderson.
Ark Anderson appears by reliable electronic means.
No
And
appearance by
Mr.
no appearance by my client, Your Honor.
All right. So the procedural facts here, we have a motion for interim relief that has been filed. It is scheduled for hearing on Monday, August 18, 2025. Today, August 15, 2025, Sam Johnson filed a motion, an expedited motion for a continuance of that interim motion hearing. Attorney Green has filed or will be filing, the court has received by email, in a document opposing the continuance of the interim relief hearing scheduled again for Monday. Today is Friday afternoon. The hearing is scheduled for Monday afternoon, and there is the interceding weekend. So the court scheduled this hearing on an emergency basis so the parties can have the opportunity to make their arguments about the continuance before the court rules upon it. Because it's Mr. Johnson's motion, I will allow him to argue first, and then I'll take up Mr. Green's argument, and then I'll make my decision. Go ahead, Mr. Johnson.
Thank you, Your Honor. So, Your Honor, I received word yesterday late afternoon, approximately 4:30 or so, that Arik's brother's daughter is pregnant and about to give birth to a child. And yesterday afternoon, they received information that her life essentially is in significant or serious danger as a result of a bunch of complications, including gestational diabetes and fetal malposition. And as a result, they literally had to move the mother to a much larger hospital to take care of this, because the hospital they were at could not do this due to the seriousness of this. So the doctors have decided that on Monday they are going to have to either induce her or see what happens on Monday. But Monday's the day where all of this just is happening. And well, of course, this involves three of my witnesses. It involves Ark's brother, Ark's sister-in-law, and Ark's mother. And all three of them wrote declarations. And of course, clearly these people have indicated that, you know, the health and welfare and safety of this child, who's a niece and a daughter and a granddaughter, is you know, more important than having to travel up here for the hearing. So so I immediately contacted Mr. Green at 4:45. I sent him an email yesterday getting off the phone. Then on my way home, he called me and we spoke for at least a half hour, 45 minutes on this. He indicated to me that he would let me know right away in the morning. I actually filed my motion yesterday. The motion was filed yesterday. It was accepted early this morning. And so, and then I attempted to reach out by more texts and more emails and so on and so forth. Now, Mr. Green's documents literally just came in. I kind of briefly read through them. He's indicating in 6.1 that I had to indicate whether or not he agreed or disagreed. And I did that. I did a supplemental declaration and indicated that I hadn't heard from him. So, so we have that. In addition, Your Honor, in his documents, he goes through a whole bunch of things. All of this is completely and absolutely irrelevant. Talks about discovery. I asked for a week extension. He granted it. All of the documents were given to him on or before December 31st. He's had all the discovery since July 31st. So that's completely and entirely irrelevant. Then I mentioned to him once, I said, hey, you know, our mediation is on the 26th. This was before any of this other stuff came up yesterday. Should we just agree maybe to continue this and try mediate it first? And we had a couple of emails on that. And he said no. And so then this came up yesterday. And then he puts in there that we haven't had time to prepare and all of that. That's just all ridiculous. I have all the documents, gone through them, gone through ARC's documents. We're meeting tomorrow morning in the event the hearing goes through. So none of that had anything to do with anything. It's what I call a red herring. So the fact of the matter is we have a family emergency. And then that's all this is about. And, you know, I can't help family emergencies. And so 3 of these family members would not be able to come. And so, and we're not asking that this matter be continued for months. We're asking that it simply not be on Monday, sometime in the future, you know, whatever is accommodating to the court and the parties. So, I don't know. Mr. Green always has these conspiracy theories that something is going on, and this is nothing going on other than had I not received a call at about 4:30 yesterday, I would not have made this motion. So that's where we're at. And so we would just ask that it be continued to a date and time mutually agreeable to the parties and availability to the court. Thank you.
So before I ask Mr. Green for his position on the matter, the rule requires interim motions to be heard within 30 days of their filing.
Mm-hmm.
In light of the court's calendar, that has been difficult. The dates that are the next dates I have available are approximately 2 weeks away, and that's without considering at all the potential for the parties or accommodation for the parties' schedules. So simply put, how do I do this? How do I afford you the relief you want and still comply with the rule that requires me to hear it within 30 days of its filing?
Well, that's the problem, Judge. And then under 6.1, for a good cause. I mean, that's just, stuff happens in life, people get sick, they get injured. I mean, Art could be in the hospital. Things happen. But 6.1 allows the court in its own discretion for a good cause to extend the rules, and amend and modify the rules, based on those things. I mean, life isn't
Well,
always.
6.1 gives me the authority to grant a continuance, but Rule 8.2 doesn't.
No, I
At least-
understand the conflict of rules, Judge, but I mean, this is just an emergency type situation. I mean, there's been hundreds of times where the courts have not been able to have a hearing within the 30 days because judges are on vacation or the calendar's full or, and, I mean, we, as attorneys, what are we going to do? Nope, you have to come back from your vacation. You're going to have this hearing within 30 days. I mean, this is just, I understand what the court is saying, but sometimes in life, this is just what happens. And the rule itself, it's just an emergency situation, and there's nothing that can be helped about that. I mean,
Well, considering 3 of his witnesses, the niece, and then, well, I don't think it, and then her husband, and then the grandmother, I think, are the 3 that he said. But all 3 of them are going to be tied up at the hospital with the niece's complications. So for 3 of his witnesses not to be able to appear, I think that's good cause. But that's my personal opinion.
so I've hundreds of times in my career, I've had interim order hearings well beyond the 30 days, hundreds of times. And, I mean, that just happens when you get emergency situations that we have no control over. So, what am I going to do? We go through the hearing and not have all my witnesses there? I mean, it's not fair to my client, it's prejudicial to my client in that regard. But that's all I can tell you,
All right, thank you. Mr. Green, your thoughts?
Well, and I had to cut my return to the motion short and I didn't even get to address the 8.2 concern that the court just brought up, but that was going to be something I was going to discuss at this hearing, is that even if the court were to continue this, we've got to find time to have this between 21 and 30 days after service. Now, you can't look at this in a vacuum. When you have the opposing party requesting, more time to respond to discovery, and they use that time to file a motion for interim relief after already knowing when the mediation date is, and now that's part of their reason, the emergency, plus we got mediation coming up. Well, I don't think mediation has anything to do with it. It certainly didn't have anything to do with it when when they filed it, because they wouldn't have filed it. They had already known about the mediation. So I don't think that the mediation even comes into play. Procedurally, the Rule 6.1 requires the motion when it's filed to include whether or not there's the other party agrees or disagrees. Mr. Johnson and I did talk last night, and he told me to read my email this morning, and I did, and that's when I started drafting all of this stuff. This stuff didn't draft itself. It took me quite a bit of time to get it done. In fact, it's taken up most of my day. Fact of the matter is, I don't think the motion's even properly before the court under 6.1, because he did not indicate that whether or not he reached out to me. And in fact, there were emails this morning between the court's recorder and Mr. Johnson and me about whether or not I opposed it, and I wasn't paying attention to my email because I was drafting all this stuff. And we certainly do oppose it. So in addition to the violation of Rule 6.1, having noted that the mediation date was already, as I put in my reply, my client's not inclined to agree to it because, yeah, I get that it's an emergency and all, but we only had 14 days to respond. And now we did it, and it was a lot of work to get that done. And now all of a sudden we want a continuance, and after we file, 35 pages or 35 documents and 65 recordings, I can understand why a continuance would be wanted. In terms of even the motion that's before the court, Mr. Johnson's I get that he's an officer of court, but his entire declaration is hearsay. I get that these witnesses are communicating with him, but he's got no declaration from them and nothing to support what's even going on other than his word. Next, even if we get to the merits of this, Mr. Johnson's talking about 3 declarations, and I was in the process or going to, it's in my queue to draft up an objection to these declarations. At the bottom of the declarations, all 3 of the declarations, it says, I declare under penalty of perjury under the laws of Kansas, the state of Kansas, that the foregoing is true and correct, and the following constitutes my signature. That, Your Honor, does not comply with 31-1505, which requires them to declare under penalty of perjury under the laws of the state of North Dakota. This is a North Dakota case, and so they need to submit themselves to the jurisdiction of North Dakota. So any one of his declarations, and these 3 are not the only 3, as my understanding, that have this in there. So these declarations are going to be objected to. I don't think they'll come in under 31-1505. So I don't know that these witnesses will come in. If the court's inclined to say, well, it's just a typo or whatever, and I'm going to allow them to come in, the next option is to have them appear by reliable electronic means. We don't need a continuance. We could do reliable electronic means. And lastly, if I had to, I'm at the point where I don't want a continuance. I'll just let them come in. I don't think there's anything that harmful in those, such that they shouldn't come in.
Okay, so they've already said that one witness is going to be either induced, giving birth, or having a C-section that day. And then 2 of her family support members are going to be in the hospital with her. You know what? If they demand that this woman zooms in, I hope she does so with her legs up in straddles.
We're not interested in a continuance, Your Honor, and if we have to go to the extreme measures, all the way to the extreme measures of saying they'll come in with no cross-examination, then I would simply request that I be able to direct exam rebuttal witnesses about those, since I can't cross-examine those witnesses. Thank you, Your Honor.
Mr. Johnson, final word. Keep it brief, please.
Yes, Your Honor. Your Honor, if the court is inclined to move forward on Monday, and if Mr. Green has, if he has no objection to electronic means, these witnesses appearing by Zoom, we still have the emergency. However, that's the least restrictive means by which, the plaintiff is affected by this. We would agree to that. First of all, we'd ask for continuance for a couple of weeks. If not, then the parties just appear by electronic means, because that's the least restrictive, means against the plaintiff. So that's my last word.
All right, thank you. The court's considered the motion. The court's considered the parties' arguments. I have read the brief
and the declarations that have been filed and reviewed the exhibits that have been provided to the court in advance of today's hearing. And again, this hearing was done on an expedited basis in light of the very short timelines and the fact that it's Friday and the hearing is scheduled Monday. Because this is an interim motion, generally evidence is received by way of declaration, and if the parties have demanded cross-examination, then the declarant must be present to be cross-examined, and generally I allow redirect after cross-examination on the declarant as a result, even though Rule 8.2 doesn't very clearly set forth that procedure. Nevertheless, I think it's fair to do it that way. Here, the court notes that the witnesses that are experiencing most directly the family emergency asserted by Mr. Johnson are not the parties, but rather witnesses that the parties have filed declarations. I'm not going to rule or pre-rule on the issue Mr. Green concerned or raised concerning whether or not those witnesses have submitted to the jurisdiction of the state of North Dakota and been sworn or declare under penalty of perjury under the laws of North Dakota. I am not a Kansas licensed attorney or a Kansas judge. I don't know what their law is without researching it. I don't know if it's the functional equivalent of North Dakota's law. I'm not going to rule on that issue in advance of tomorrow or the hearing. I'm going to deny the request for a continuance. However, I am going to permit cross-examination to occur by reliable electronic means, and I will allow the appearance of those three declarants by reliable electronic means if we get that far. That's probably the best way of putting it, because it sounds like Mr. Green will be filing an objection or raising an objection at the hearing to those declarations. If the court receives those declarations, the court will contemporaneously allow those witnesses to appear remotely by Zoom with audio and video, and Mr. Green will be allowed to cross-examine on that basis. Mr. Johnson, because you were the movant and you, well, just because you're the movant, I'm going to ask that you prepare a very brief order, proposed order, and file it just saying, for the reasons stated on the record, the continuance is denied. Witnesses are allowed to appear by Zoom, and then include the court's connection information in the proposed order. And I will review it when I get to Minneapolis and sign off on it. It probably won't be filed until Monday. Well, I will sign it if you get it filed by Friday, but it won't be received with the clerk's office being closed over the weekend. It probably won't be received by the clerk's office until Monday morning at 8. Does everyone understand my order, Mr. Johnson?
Yes, Your Honor.
Mr. Green?
Yes, Your Honor.
Anything else we need to address today?
No, Your Honor.
No, Your Honor.
All right. With that, we are adjourned. Have a good day.
Thank you.
And
Thank you.
We'll just go ahead and get started.
So she has gestational diabetes and some other health complications, and they have to, by emergency, either induce labor or do a C-section. They don't know which, but what was testified to is that her life, health, and the health of the baby, they're all at jeopardy right now. So, yeah, that I know us moms are more upset about it than the guys are. I get that. Hey, I'm gonna try, but YouTube doesn't like me getting cases lately, so I can't promise anything. I know. Hey, that means I gotta go to bed eventually. So yeah, I will try. Mustache bro. Oh, I believe you. Yeah, I get that. I mean, and the court rulings are not meant to appease anybody's emotions, and they shouldn't be. But I very much dislike it. Oh, yes. Oh, yes. Oh, yes. I love you all. This is the state of Florida. And we're about to watch the epic bench slap of the Court of Appeals on an attorney.
With counsel for appellant, please.
Good morning. My name is Bailey Lowther, and I'm the attorney for Somali Ang.
I am Casey Bushelon. I'm the attorney for Bun Tao.
Okay. All right. I don't see anyone else on my screen. Okay. I'm just going to start this morning by providing a little bit of the procedural background that tells us what led us here today. Ms. Lowther, it's my understanding that you filed your notice of appeal on behalf of your client in January of 2025. After you did that, our court notified the parties that the case was being pre-screened for our appellate mediation program. That order that we issued in February of 2025 required both sides to complete and file several mediation forms with the court. Both parties did that. And on March 6, 2025, our court entered an order of referral to mediation. That order of referral to mediation also required appellant to file a response within 10 days. Appellant did not do that, though, and we had to enter a follow-up order requiring appellant to file its response within 5 days. Ms. Lowther, it looks like your client did that and complied on March 26, 2025. And the parties notified the court that they had jointly selected Mr. Stephen Chase to serve as the mediator in this case. On March 31st, our court appointed Mr. Chase as the mediator, and that meant that the parties then had 60 days to complete their mediation. But on June 10th, 2025, Mr. Chase filed his required mediation report and informed us that, quote, despite several efforts, the mediation could not be scheduled, and it is the mediator's understanding that the parties have not filed a motion to extend the deadline. So then on July 1st, 2025, our court entered an order to show cause, ordering appellant to file a status report within 10 days, setting forth the date and time selected by the parties to mediate the case, and requesting that the court extend the time to complete the mediation accordingly. In addition, we ordered appellant to show cause in writing why sanctions should not be imposed against both the appellant and appellant's counsel, Ms. Lowther, personally, for the failure to comply with the order referring the case to mediation. My understanding is that as of today's date, we still have not received any response to that order to show cause. Because we did not timely receive a response on July 22nd, 2025, this court set the show cause order for hearing, which we are here for today. And we also ordered appellant and its counsel, Ms. Lowther, to file a notice within 5 days indicating that you received the order setting today's show cause hearing. But it's also my understanding, Ms. Lowther, that no notice was ever filed with us. At least I didn't see one as of this morning. So I think what I would like to start by asking you, Ms. Lowther, is if you could please provide us with some background and what's going on your end that has led to your failure to comply with several orders entered by our court.
Thank you, Your Honor. Everything you have said, I believe, is absolutely correct. My initial delay in complying with scheduling the mediation was the result of difficulty communicating with my client, who was in Cambodia, where she is from. And so I was simply unable to reach her. When I did finally reach her, she did confirm that, you know, she was available and willing and able to move forward with, you know, the appeal and the mediation. But I was then unable to contact her for a significant period of time, again, interfering with the scheduling. That being said, all of the fault here lies with me, not my client. My client is originally from Cambodia. Her English is not good. You know, when I speak with her, her brother-in-law acts as our translator. But, you know, I have to confess that I do sometimes find myself uncertain as to exactly what she does and does not understand. So, you know, I would simply say that all of the fault is mine. I failed to comply. I have no, you know, real excuse for it. Any difficulty communicating with my client is my responsibility. And certainly I should have notified either, you know, Mr. Bouchon and Mr. Chase and or the court, you know, of that situation. And it was completely my fault that I didn't do so. So I would simply ask that any sanctions be directed to me as opposed to my client.
Ms. Lowther, when I understand that it's difficult to communicate with your client, but I'm curious as to why, when we've asked, you know, when we sent a show cause order, why did you never file anything with us telling us that you were having trouble communicating with her? She's out of the country. Maybe there's some uncertainty. Why wasn't there anything just filed on your end saying, here's what's going on?
Your Honor, to be perfectly honest, I don't know. I have no good excuse. This is the first time in my career that I have ever acted in this way, that I've ever failed to comply with a court order or missed a deadline. You know, I could give you a litany of, you know, personal and professional stressors, but I don't think any of those excuse my conduct. You know, I really have no excuse.
Okay, but you did receive the various orders. Did you receive the initial order to show cause requiring? Okay, did you calendar that? It gave you 10 days to file a response in writing.
I did. I really had no good response. You know, as I said, I absolutely should have communicated with, you know, all other counsel, you know, and the mediator and the court as to the status and what was happening, and I failed to do so.
So, ma'am, are you telling me that you're receiving our orders, you're calendaring the deadlines, and then just disregarding them? Is there an alert system telling you when you have something due or an assistant who helps you with that?
To be clear, Your Honor, I was not unaware of the deadline. You know, I did not forget about it. I simply did not know how to respond.
I see. So you were concerned about like the content of what your response to the order would have been.
Correct.
Okay. And then what about, let's see, on July 22nd is when we set this show cause order for hearing. And all you had to file with us was a notice, right, in 5 days indicating that you had received it so that we know to assemble the team, to make sure we have all the judges on the line, to get our IT people in place so that we don't come online unnecessarily. We want to know, in addition to other things, we want to know that you all will appear for the hearing and that will not all be for nothing. Why didn't you file a notice just indicating to us that you had received the order setting the show cause hearing?
To be perfectly clear, I think when I saw it, I was so horrified by it that I failed to read it through completely and simply calendared it. And overlooked the requirement to file a notice.
Okay. Did you inform your client about all of this going on with all of the show cause hearings and that you had to appear today?
When I last spoke with my client, when I last had contact with her was at the end of July, and I did inform her of the status at that time.
All right. Chief Judge Traver, do you have any questions?
I do. Thank you, Judge Brownlee. What have you done since that time that you spoke with your client about getting the mediation set?
I'm sorry, Your Honor, I couldn't hear you.
What have you done since the time that you last spoke to your client, or since when you just said that you spoke to your client at the end of July? We're now sitting here in the middle of August. What have you done to get the mediation set?
I have not been able to do anything, as I have not been able to contact her to confirm her availability.
I mean, you're under a court order to set a mediation. What have you done to try to do that?
Well, Your Honor, I have been trying to, I have reached out to my client and asked her to contact me with her availability for the mediation.
How often have you tried that in the last 6 weeks?
I would say approximately once a week, maybe twice a week.
We're in a situation where, say, your client got back to you today, your opposing counsel has his schedule and his clients, you have your schedule, the mediator has his schedule. Let's assume that you can get this mediation set by the end of September, which is 6 weeks from now. That basically means by your admitted conduct and inaction, we're looking at least a 4-month delay in this particular case. Because mediation was supposed to be completed by the end of May. What do you think is an appropriate sanction against you for delaying an appellate case for 4 months with no good reason or explanation for it?
I have thought about that, Your Honor, and I don't know. Certainly, I think that I should be responsible for any costs, incurred. Beyond that, I simply am not sure. I have considered it. I just don't know.
I mean, this isn't something that any of us at this court enjoy doing.
How about losing your license? Because this is absolutely unacceptable. And no court is going to tolerate this.
The whole point of the mediation program is not to inject unnecessary adversarial conduct into a proceeding. And yet here we are after a show cause order where you've admittedly failed to respond to 3 different of our orders. And it's taken Judge Wozniak and Judge Brownlee and your colleague away from other things that all of us could be doing over the course of that particular time. I say that as a minor point. My last question for you involves, I guess, a degree of concern on my point that if you are not able to respond to multiple court orders from the 6th District Court of Appeal, I have some concern as it relates to your office setup and your ability to respond timely to your clients in your other cases. I wonder if that's best left as an observation, or if I asked you a more general question of what is the sort of help that you are getting in your office? Are you a solo practitioner? Do you have an assistant? What type of calendaring system do you have to make sure that you are fulfilling all of your obligations to your clients and to trial courts and appellate courts throughout the state?
Absolutely, Your Honor. First, I assure you this has been certainly not a one-time event in this case, in that I've had multiple infractions, but this case has been unique in my experience. I've never had any other difficulties meeting any deadlines in any other cases. I am a solo practitioner. I do have a part-time assistant who helps me on an as-needed basis. For example, right now I'm preparing for a trial beginning Monday. And so, she has been in my office this past week, helping me with documents, getting everything ready. My calendaring system, I primarily rely on a paper calendar. That's simply what I prefer. But I also do use Outlook, which I have synced up to where when I receive various hearing notices, notices of deadlines, they are saved in my Outlook calendar, so they appear there as well.
Judge Brownlee, I don't have any more questions.
Thank you, Chief. Judge Wozniak?
I have one question. I'm looking at your Florida bar profile and I see that you graduated from law school in 2001. So if that's accurate, you're not a new attorney, correct?
Correct.
Okay, but you were admitted to the Florida bar in 2017, is that right?
Yes.
Okay, so what are you admitted in any other jurisdictions?
I am admitted in Texas. I am inactive simply because I've never practiced there. I was planning to, but never did. And then prior to Florida, I practiced in Louisiana up until 2010, which is when my husband and I moved to Sarasota. And then from 2010 to 2017, I was not practicing. We have 4 children, so I was at home with them. And then I took the Florida bar in 2017.
And there have been no issues like this, any show cause proceedings, sanctions, reports to the bars, anything like that in any of these other jurisdictions?
No, not in Texas or Louisiana. In Florida, in the interest of full disclosure, I have had 2 bar complaints. One was filed by the plaintiff in a case in which I represented the defendants. And that was found to be, completely unfounded. The second was filed, and I apologize because I cannot remember the approximate time frame. I think it was about 2020. The second was filed by a couple who had consulted with me while I was at my prior firm about representing them in a case that had been filed against them in Massachusetts. And at that time, I advised them that I am not licensed in Massachusetts. And, I told them that they would need to get an attorney there. And then subsequently, I guess, for whatever reason, weren't entirely clear on that. And they did end up having a judgment entered against them. They never did hire a Massachusetts attorney and had a judgment entered against them in small claims court in Massachusetts and filed a bar complaint against me alleging that I had told them that I would represent them in that case. And I received a private reprimand and took a ethics class.
Okay, those are my only questions.
Thank you.
Ma'am, what's your primary area of the law that you practice?
I do a good bit of insurance litigation, typically representing property insurance, not personal injury. A lot of hurricane type claims, storm damage. I do construction defect work, and then I also do commercial litigation as a whole, I would say, but primarily, I would say about 80% of my practice is construction defect or Johnson v. Davis type claims, and then also property insurance claims.
Have you ever handled an appeal from inception to from notice of appeal to mandate?
Not in Florida, no.
But you have in other states?
I believe, yes, in Louisiana, and that would have been back in, I believe, 2005 or 2006, and I cannot recall if I handled it from start to finish, and also at the time I was with a firm, so I would not have been handling it by myself.
Okay. I guess one thing I'm concerned about, ma'am, to be frank, is, when we leave here today, whatever goes on ultimately with the mediation in this case, if you continue to represent your client continues to wish to pursue the appeal in this matter, there are going to be several orders that come down the pike. You're going to have deadlines where there's going to be motions for extension of time, perhaps, for example. There's going to be orders. I guess I'm very concerned that of your ability to comply with the orders that we enter in this case as it proceeds. And I'm wondering, are you also concerned about that?
As hard as this may be to believe, I am not concerned about that. As I said, this the failure on my part over the past few months to respond to this court's orders has been unique in my experience. I am quite confident that going forward, I will not have any difficulty complying with the court orders.
You feel capable with your current calendaring system of representing someone before our court?
Absolutely.
Judges, anything further from anyone? Okay. And counsel for appellee, sir, is there anything that you need to bring to our attention at this moment?
No, Your Honor.
Okay, thank you. All right, we will take this under advisement and issue an order. Everyone have a nice day.
Thank you, Your Honor.
Ooh, I want to know what that order is. That hearing was just today, so they're probably still deliberating on it. I don't know how long it takes to get a Court of Appeals order from Florida, but I will be keeping my eye open. Hi, how did you get so wet on your bandana? You were sleeping. Did you drool all over yourself? It's either that you drooled all over yourself or you just went and got a drink. And I really hope that it wasn't from the toilet because I just touched it. Oh my goodness. You guys, you have been so funny tonight. You've absolutely kept me just laughing my butt off. Yes, absolutely. But that was a hard beatdown. Well, it's quite possible because the bandana does kind of hang when she's, got her face in the bowl. Y'all are super pretty. Oh my goodness. Wait, you gotta go potty? All right, guys. That's what she does when she wants to go outside. She just comes up and sits there and waits for me to say the words. Thank you so much. Trust me, you guys are what make it great. Right? That's my concern. She acknowledges that she's made mistakes. And she just expects the court to trust that they just won't happen anymore. I don't know how much I believe her. What are you doing differently? What are you going to do differently? That's what I want to know. Thank you for being here. Thank you so much. It's possible. Anything's possible. What I do believe is that she can't handle her job. Maybe she's one of those lawyers that needs the backing of a firm. Maybe she just can't solo it. It's, I mean, right? Yeah. Still using a paper calendar. That's what got me. Because, that's almost impossible to keep track of everything like that anymore. Same. Yep. Jeremy, it was so good to have you in chat tonight. Absolutely loved your commentary. K. John Boom, and I know our sweet Mortimer Duke fell asleep in his recliner. He's got it running still, but he's knocked out. All right, guys. Y'all are the best. I truly mean that. Be safe, be well, sleep sweet, and much love.